See, by the end of
Mhm.
this workshop, you should be able to appreciate the statutory role of directors and company secretary in enforcing corporate finance, corporate compliance, and management as enshrined under Companies Act. Draft various documents and fill in necessary statutory forms relating to management of a company. That's the first outcome.
Yes, proceed.
The second one is draft the statutory documents required to convene and conduct board and general meetings of a company. Explain the different sources of corporate finance. Understand the statutory corporate procedures related to calls on shares in preemption and forfeiture. Address challenges in respect of corporate management, specifically enforcement of shareholder member statutory rights. Identify any ethical issues disclosed.
Okay. As I earlier on told you that corporate and commercial is a transactional cost unit. It being a transactional cost unit is divided into different stages. And among these stages, we have one, incorporation. Okay. We have management and then dispatch of company, business, and then corporate financing. When you look at the first one of incorporation, that's what you dealt with in your first workshop, okay? And management, okay? Incorporation is what we call registration of that company so that it gets what we call a corporate personality. Once it has acquired the corporate personality, okay, for it to start dispatching business, it should be managed. Then you ask yourself, management of a company is done by who? By the directors, members, shareholders, secretaries, auditors. So I'm very sure that you covered all that. Now, after understanding who does the management of a company, then you proceed and appreciate how do we dispatch company business. Okay, dispatch of company business basically requires things that companies do, okay, to survive, and these include meetings, okay, making a call on shares, and then borrowing and everything. So your workshop of today is basically dealing with dispatch of company business. So you should, by the end of this workshop, you should be able to appreciate how the different types of businesses are dispatched. Okay? How the different types of business and how they are dispatched. Okay? So that means if the type of business is making a call, ask yourself who makes a call and how is it made. Okay. If the type of business to be dispatched is borrowing, if the type of business dispatched is defending a suit, so that's what you're going to be dealing with. So essentially, dispatch of company business is done through the process known as meetings. So by the end of this workshop, you are presumed that you would have appreciated all the above. Okay. So let's get to the workshop now. Council, take us to the facts.
Excuse me, Council.
Yes.
Allow me to have that intro a little bit again. I've not appreciated it well. I am very sorry. How you come to these meetings and how we differentiate between the other first workshop and this one. We are going to just give me a chance.
We've said that corporate and commercial is a transactional cost unit. So it being a transactional cost unit, basically, these transactions have stages. We've said the first stage is incorporation, and then the next stage is management. The third stage is dispatch of business. The fourth stage is corporate financing. Your first workshops dealt with establishment of a company and management. Okay, that is to say, what is a company, types of companies, the process of incorporation, then directors, secretaries, auditors, members, shareholders. So after you appreciating who can manage this company, then you proceed and go to what we call dispatch of company business. And this is what we are dealing with today, dispatch of company business. So you ask yourself, which type of business is dispatched in a company? So we may have different types of businesses. We may have increase of share capital, decrease of share capital. We have borrowing, we have buying land. Okay, we have making a call, all. So it depends how the workshop is structured and what type of business is there. Okay.
Thank you, Council. I'm now on the board.
Okay. So, Council Faith, are you in possession of the Companies Act?
Without always, I don't know where my amendment is, but the old one I have.
Okay. Council, take us to section 140.
Length of notice for calling meetings.
Yes.
Okay. Any provision of a company's articles shall be void insofar as it provides for the calling of a meeting, the company, other than an adjourned meeting by a shorter notice than 21 days.
So what does that mean? That any type of meeting that should be called should not go below 21 days unless otherwise. Council, proceed.
Subsection 2. The notice under subsection 1 shall be in writing. Subsection 3. Except where articles of a company make other provision, not being a provision declared to be void for the purpose by subsection 1, a meeting the company, other than an adjourned meeting, may be called by 21 days notice in writing.
So it still emphasizes, okay, that a meeting of whatever business to be dispatched unless otherwise, it should be over 21 days. Answer, proceed.
Subsection 4. A meeting of a company shall, notwithstanding that it is called by shorter notice than that specified in subsection 3 or in the company's articles, as the case may be taken to have been called if it is agreed, A, in the case of a meeting called as the annual general meeting by all members entitled to attend and vote at the meeting. And In the case of any other meeting, by a majority in number of the members having a right to attend and vote at the meeting, being a majority, together holding not less than 95% in nominal value of the shares, giving a right to attend and vote at the meeting, or in the case of a company not having a share capital, together representing not less than 95% of the total voting rights at that meeting of all members.
Okay, so take us to 141. So the notice they're talking of, okay, under 140, it should comprise, its contents should match with 141. Let's proceed.
General provisions as to meetings and votes. The following provisions shall have effect insofar as the articles of the company do not make other provisions for the purpose. A. Notice of the meeting of the company shall be served on every member of the company in the manner in which notices are required to be served by Table A, and for the purpose of this paragraph, the expression Table A means the table as for the time being in force.
Proceed, guys.
2. Two or more members holding not less than 1/10 of the issued share capital, or if the company has not a share capital, not less than 5% in number of the members of the company may call a meeting.
Okay.
C. In the case of a private company, 2 members, and in the case of any other company, 3 members personally present shall form a quorum.
Okay, so that means if you send a notice, okay, calling for a meeting, and you are 20 and it's a private company and 2 people are present, you can proceed in the absence of the rest. Let's go on.
Any member elected by the members present at a meeting may be chairperson of the meeting. And then, in the case of a company originally having a share capital, every member shall have 1 vote in respect of each share or each 25 currency points of stock held by him or her, and in any other case, every member shall have 1 vote.
Okay, so that's how we call, or it is what meeting we don't care. What that means, every meeting that is going to dispatch company business should be called for by a notice. Okay, so now after appreciating that, then you ask yourself, okay, what are the different types of meetings that we should convene? Okay. Yes. So, how many types of meetings do we have?
We have ordinary meetings. We have extraordinary meetings. Named that as a Sijukira. I think there could be like 3.
Okay.
General, annual, something.
So, we have different types of meetings. So, when you look at your learning outcomes, they are emphasizing some types of meetings. Okay, so we have what we call board meetings. We have general meetings, what we call annual general meetings. We have extraordinary meetings. We have court-ordered meetings. We have statutory meetings. Okay. And class meetings. But all those provisions are under the Companies Act. Okay. So let us look at those meetings.
Council
Yes,
and statutory meetings for public companies.
now we shall see, Bola.
I didn't think they would make it to our list, that's all.
No, because you first read and then you start dealing with one by one. Okay.
Okay.
Yes. So, Council, which law provides for meetings? Yes.
Provides for meetings.
Which law provides for meetings? Yes. I'm asking the entire class. Okay, let's start on the meetings. Council, take us to section 137.
Meetings and proceedings.
Yes.
Statutory meeting and statutory report. 137. Subsection 1. A company limited by shares and every company limited by guarantee and having a share capital shall, within a period of not less than 1 month or more than 3 months from the date at which the company is entitled to commence business, hold a general meeting of the members of the company, which shall be called the statutory meeting.
Okay, so that is a statutory meeting. Okay. Council, read it, Mpola. We'll break it. You will read that provision again.
A company limited by shares and every company limited by guarantee and having a share capital shall, within a period of not less than 1 month, no more than 3 months, from the date at which the company is entitled to commence business, hold a general meeting of the members of the company, which shall be called the statutory meeting.
Okay. So you see, so it is for a private company, Council. Okay, because it is the company which has a share capital. Okay, so upon incorporation, you have that period to convene that meeting. Okay. Council, go to section 138.
Annual general meeting.
Yes.
A public shall in each year hold a general meeting.
Council, public.
A public company shall each year hold a general meeting in addition to any other meeting in that year, but shall specify the meeting as general meeting in the notices calling it, and not more than 15 months shall elapse between the date of one annual general meeting of a company and that of the next. A private company may, at the requisition of a member, hold an annual general meeting.
Okay. So what does that imply? That implies that what that means that annual general meetings are not mandatory. In a private company. Okay. Are we together? Okay. So it is upon requisition of a member. Okay. So it is literally not compulsory in a private company. Let's go to 148.
Special resolution?
No.
But I've never read anywhere where the act talks about that extraordinary meeting, but I know it gives a special resolution.
We shall get there. Don't worry, and we see. Okay. Then let's go to extraordinary general meetings. Okay. Section 139.
Convening of an extraordinary general meeting on requisition. The directors of a company, notwithstanding anything in its articles, shall, on the requisition of the members holding not less than 1/10 of the paid up capital of the company as at the date of the deposit, carries the right of voting at general meetings of the company, or in case of a company not having a share capital, members of the company representing not less than 1/10 of the total voting rights of all the members having that date a right to vote at general meetings of the company shall proceed duly to convene an extraordinary general meeting of the company.
Okay, so you see, also the extraordinary meeting is upon requisition. Okay, but by a particular group of members having a particular type, a particular shares being paid up. Okay, we shall get there, Paula. Okay, then Council take us to 142.
Power of court to order a meeting.
That's what we call court-ordered meetings.
Where for any reason it is impracticable to call a meeting of a company in any manner in which meetings of that company may be called, or conduct the meeting of the company in the manner prescribed by the articles of this act, the court may, of its own motion or on the application of any director of the company or of any member of the company who would be entitled to vote at the meeting, order a meeting of the company to be called, held, and conducted in the manner the court thinks fit.
Okay. So court has such powers. Okay. For example, we have a case of Justice Sekana where the company had to convene meetings, but in their memorandum and articles, they had not included what we call circulation meetings. Okay, meetings via Zoom. They had not included them. So as a result of that, they made an application and the court ordered them to convene meetings via Zoom. Okay. So now, I'm forgetting the parties, but I'll get it. Okay. Then after that type of meeting, we have another type known as board meetings. Board meetings. Council, go to table A. Go to table A. First read Article 8.
Powers and duties of directors.
Yes.
The business of a company shall be managed by directors who may pay all expenses incurred in promoting and registering the company and may exercise all such powers of the companies as are known by the Act or by these regulations required to be exercised by the company in the general meeting, subject to these regulations and to the provisions of the Act and to such regulations, being not inconsistent with these regulations or with the Act, as may be prescribed by the company in general meeting.
So what that means, okay? What that means, okay? That the general duty of management of a company is in the hands of the directors, okay? So that whatever thing is done should in management, directors should have a say, okay? That's why most of the people who are in management, okay, are appointed by directors, okay? Are we together?
Yes.
So, Council, take us to Article 98. It is the law that provides for board meetings.
Proceedings of directors.
Yes.
The directors may meet together for the dispatch of business, adjourn, and otherwise regulate their meetings as they think fit.
You see, so the directors may meet together from time to time to dispatch, okay, business. You see, have they told you? That's why this topic is known as dispatch of company business. So from at that very point, you need to ask yourself, what type of business is dispatched by directors in a board meeting? Because remember, your first learning outcome is so much centered on directors. You recall that? So the first thing, let us go to 79, Article 79. So that is the first thing directors can do.
Borrowing powers.
Yes.
Directors may exercise all powers of the company to borrow money and to mortgage or charge its undertaking, property and uncalled capital, or any part of it, and to issue debentures, debenture stock, and other securities, whether outright or as security for any debt, liability, or obligation of the company or of any third party, except that the amount for the time being remaining undischarged of monies borrowed or secured by the directors, apart from the temporary loans obtained from the company's bankers in the ordinary course of business, shall not any time without the previous approval of the company in general meeting exceed the nominal amount of the share capital of the company for the time being issued, but a lender or other person dealing with the company shall not be concerned to see or inquire whether the limit is observed.
Okay.
Proceed.
So no. Okay. So what that means that the directors, the first thing, whenever you are reading that act and you say the directors may, that indicates that that is business dispatched by the directors in a board meeting. Okay. Are we together? Then Casa, take us to Article 15.
Article 15.
Yes.
Of table C. Calls on shares.
Of table what?
So I'm reading calls on shares. 15.1. The directors may from time to time make calls upon the members in respect of it, all or any monies unpaid on their shares, whether on account of the nominal value of the shares or by way of premium, and not by conditions of allotment of shares of the shares made payable at fixed times.
So, what does that mean? Making a call is like making a demand or kubanja. When you open up a company and let's say Faith agrees that she'll take 10 shares, okay, and then Apophia agrees that she will also be able to take 20 shares, okay. So by virtue of that agreement, Faith has to pay all her shares, and then Apophia should also pay all her shares. So where these guys have paid a quarter or half, the company still demands them. Why? Shares are properties of the company. So the company should demand that, oh, when nawe bintu byange nga tampa sente. So that's what we call making a call on unpaid up shares. So when you read that provision, it talks about the directors. So that means it is the duty of the directors to make a call on shares. So after that, ask yourself, what is the process of making a call on shares? Okay. Okay. Council, we want to look at the process of making a call. Okay. So, but before you make a call, there are what we call conditions. Okay. Okay. So, the conditions, Council, let's look at the conditions. So, the first condition, okay? Council, go to Article 15, Clause 2.
A call shall not exceed. A call shall not exceed 1/4 of the nominal value of the share or be payable less than 1 month from the date fixed for the payment of the last preceding call.
So what does that mean? That when you are demanding, when you are making a call, okay, you should not exceed a quota, okay? You should not exceed a quota. Now, to be honest and realistic, kiringa ng'obanja omuntu emitwalo 5 olina ekizibu ewaka mu nju yo, okay? Olina ekizibu ewaka mu nju yo, omwana wo mulwadde omubanja 5 naye ogenda obikola endagaano ng'endagaano egamba bw'oba ommanja emitwalo 5 nzikirizibwa kuwaako omutwalo gumu mu 600 buli lw'ommanja. Omutwalo gumu mu 600 kuba gugenda kugasa ki? Abanga atakoze eki? Atakuyambye. So, let's proceed. Now, Council, proceed and read Clause 3.
Each member shall subject to receiving at least 14 days notice specifying the time and place of payment paid to the company at the time and place specified the amount called on his or her shares.
What does that mean? Okay. That the first step in making a call is issuance of a notice. And that notice should be a notice of how many days? 21 days. Okay. Okay, how many days are mentioned?
14.
14, okay. So then, after issuing a notice, that notice, its contents are mentioned under Clause 3. It should specify how much I'm supposed to pay, when, and where. Okay? So if it is specifying the date when I am supposed to pay, okay, and that date expires, okay, what should we do? Council, take us to Clause 18.
Clause?
Article 18, sorry.
If a sum called in respect of a share is not paid before or on the day appointed for its payment, the person from whom the sum is due shall pay interest on the sum from the day appointed for payment of the sum to the time of actual payment at such rate not exceeding 5% per year as the directors may determine, but the directors may waive payment of such interest wholly or in part.
So what does that mean? If I don't pay, okay? If I don't pay, they will issue me with a reminder notice with an increment of 5%. Nti mbadde nasasula gumu kitundu, bwe mba sigusasudde nina okusasula ogumu ekitundu, ogwo gwe mbadde nina osasula nga nnyongeddemu 5%. Okay? Then what happens if again in that increment, okay, I don't pay? Yes? Yes?
Should I read 19?
Yes.
A sum which by the terms of issue of a share becomes payable on allotment or at any fixed date, whether on account of the nominal value of the share or by way of premium, shall, for purposes of these regulations, be taken to be a call duly made and payable on the date on which, by the terms of issue, it becomes payable. 2.
Okay.
In case of non-payment, all the relevant provisions of these regulations as to payment of interest and expenses, forfeiture or otherwise, shall apply as if the sum referred to in sub-regulation 1 had become payable by virtue of a call duly made and notified.
So what does that mean? Okay. That if I refuse to pay, they have issued me with a notice, they have increased the 5%. Byonna we bigana, we shall proceed and we do what we call forfeiture. Forfeiture mu Luganda kye bayita okweddiza. Okay? So we shall take back our shares. Tugaye musiraamu, olemereddwa okusasula munnaye. So shares zaffe zituwe. Okay, zituwe. You cease to be a shareholder. Okay. So when forfeiture happens, that's when one ceases to be a shareholder. But before forfeiture, you don't have a right whatsoever to say that I'm not a shareholder. Oba nsasudde, oba sisasudde, I am still a shareholder. I still have shares in your entity. Okay? So someone in Oros was asked counsel, at what stage does someone cease to be a shareholder? Hey, and Navagamba, upon failure to pay. Okay? So it is not upon failure to pay, it is upon forfeiture. Okay? Are we together? Okay? So first stop on those provisions. Let's go back now to our facts of workshop 1.
Should I proceed?
Yes. The facts are small, eh? Mm-hmm.
Upon the incorporation of Nama Venue Energy Limited, which was given
Kyenkakasa mwenna temujjukira facts za workshop you are referringako lino eggwanga olemwa. Tugende maaso.
Upon the incorporation of Nama Venue Energy Limited, as was given in the facts of the last week of corporate, the company started operating business. The company has implemented various projects in the Ministry of Energy where it was contracted to supply electricity to various towns in the eastern region. On commencement of business of the company, Young paid 250 million out of the 500 million. He promised to invest in the company.
Now, you underline, okay, Council, you underline the balance. If this guy was supposed to pay 500 million, he paid 250. He still has a balance of 200. So that means those are what we call unpaid up shares.
Yes.
How we proceed?
Moranga Carson and Rashid each paid 25 million out of the 50, each promised to invest in the business.
What does that mean? The company still demands them. Questionable.
Yeah.
We proceed.
It was agreed that Yang Shikang, a Chinese national, and Moranga Carson to be directors of the company, while Nkoyoyo shall be made secretary. Sure.
So now, what are the duties of those directors in regards to Kubanja to gain the mass?
The trio agreed to all actively participate in running of the company business. Yang will once in a while fly from China into the country to attend company meetings and execute company documents.
Yes.
As a result of the Ebola outbreak, there is a ban on travelers from Uganda entering China. As a result of the above, Yang is worried that it may take a long time for him to come to Uganda, which may greatly affect the company business.
So how can he convene that meeting? That's what we call saturation meetings. To gain a mass. In December
2022, the company won a tender with Ministry of Energy to construct several electricity lines to connect several small towns in Acholi sub-region under semi-urban electrification program. The tender is worth Uganda shillings 10 billion.
Now, when you look at, they give you 10 billion. Njagala ogatte sente eziri waggulu eri, kolabo ba company ezirina. You get it? Kati another challenge, or could anyway to proceed. Let's okay today. Hope you guys have your workshop.
The company signed a contract with the ministry where it was agreed that the work should commence by the end of February 2023. The directors of the company are worried about raising over shillings 5 billion needed to start the works on the project. Nkoyoyo Rashid has approached Stanbic Bank to borrow on behalf of the company at least 2 billion using the land where the office of the company is situated in Mokono as security.
Now, ask yourself, underlining the name Nkoyoyo. Can Nkoyoyo borrow money? Nkoyoyo is a secretary, not so?
Yes.
Council, we looked at the power to borrow is by who?
Is by the directors.
Tugende mu maaso. And on top of that, look at the money they want to borrow. To what?
It's above their capital nominal value.
So you should go back in your first workshop and look at the nominal capital. How much was the initial capital of this company? We read Article 79, which says that you can't borrow beyond. Okay? So if it is, this money is beyond, we have a remedy, but you have to first confirm. Okay, we proceed now.
Young is willing to mobilize at least shillings 500 million from his family members in China, which he can invest in the company. Young wants a bigger stake in the company as a result of the above investment.
That's what we call shareholders' loans. We proceed.
The directors are worried on how to raise the other required monies since they don't have any other securities which could enable the company to secure more credit from financial institutions.
Now, after that, they want you to talk about other modes of capital financing. Okay. You have to go back in your workshop. The mwakola eri osokola be company erina shares maker. Okay, so from here tulina betubanja, we shall first make a call. Bwe bagana okusasula, we shall forfeit. Okay, tweddize shares. After the company gets shares, it can deal with those shares the way it wants. So that can take you to what we call allotment of shares. Okay.
Should I proceed?
The
directors are worried. Oh no, how Mazeo. Stanbic Bank has requested Nkoyoyo to furnish additional statutory information related to the company in order to ascertain if the same is compliant with the requirements of the law governing companies. However, all that is available from the Office of the Registrar of Companies is the articles and MOA that were filed at incorporation. The directors have agreed and resolved to approach you as a young lawyer, not bush lawyer, for legal guidance on the compliance requirements of the company.
Have you ever heard of what we call the Indo management rule?
Yes, we did it in the last workshop.
So as a result of that, you are under an obligation to ensure, okay, that whatever is supposed to be done before you borrow, it is done. You've passed the resolution to borrow. You are borrowing money within your ambities. If the money you want to borrow is above, you have to pass the resolution increasing share capital, amendment of memorandum and articles of association. Let's go to what they want.
Advise the company on the possibilities of transacting business in the absence of Yang Shichiang. Prepare and update the company. Prepare and update the company file to ensure that it is compliant with the Companies Act.
Those are what you call requirements of borrowing. Okay. Yes.
Explain the rationale for the registration of the forms and documents above. Bring the documents and forms to class. Advise the company on the possible sources of internal funding. Explain the amounts the company can raise and the time limits involved. whether there are any exceptions of obtaining the required funds in case Mr. Lingley is unable. This Lingley, aren't we talking about Mr. Young?
Maina kuba Young, just ring.
Assuming that the offer from Yang Sichang is taken by the company, advise on how his wishes can be fulfilled. How should this transaction be structured? In case the company obtains funds from Mr. Yang Shichang by way of redeemable preference shares. Explain the process of redemption of the company's shares. How do we redeem them?
So now, tukubye kugundi because you're making a call. So now, your workshop 1 basically requires you to discuss what we call corporate financing. Okay, now I'm explaining corporate financing. Okay, so corporate financing, this is the process through which a company is able to raise capital. Okay, is able to raise capital in order to survive. Corporate financing is divided into 2. We have what we call equity financing and then debt financing. Equity financing, these are known as internal modes of getting money. Internal, they emanate within the company. Okay? Not anywhere else. Okay? So the company has to first ensure, it's like you human beings, when you want money, okay, totandikira wa money lender. Okay, otandikira mikwano gyo, kati woba olina emikwano emyavu kaba kaweddemu. Okay, okay, so that is what we call mikwano gyo bwe giba tegirira n'okubirako ab'ewaka, n'okubirako boyfriend, n'okubirako tycoon. Okay, so that you see if within your circle you can get money. That's what we call internal modes. So but where you realize wallahi bwensubiramu akasente takakola ki naye takalaba. Awo ng'omanya kirabika bano tebalina. Okay, so then nga weebuuza nzijjeewa. Okay, then you ask yourself nzijjeewa sente. Okay, so that's when you proceed and go to what we call external modes of financing, all. Okay, what we call debit financing. Debit financing, basically you'll be looking at, yes,
debt financing.
Okay, debt financing, that's basically borrowing from external sources. That is to say, money lenders and financial institutions. Okay, money lenders and financial institutions. That's when you should ask yourself, how much can we borrow? Okay, like that. Okay, so now let's list what we call the modes of internal borrowing, or what we call equity financing. Okay, We basically have three. Yes, you'll get confused what and have you, but we basically have three modes of capital financing that are equitable. The first one is okay.
Akachi. Council
The
we did.
first one. Yes. Okay. The very first one is what we call making a call on shares. That is the first one. Eyo tugimanyi kati non so? Yes. Do we know how to make a call now?
Yes.
Then the second one is known as allotment of shares. Allotment of shares. Okay. But before you say you're going to talk about allotment of shares, you should ask yourself, what is the nature of shares? Okay. What is the nature of shares? We all know that the nature of shares, the law is clear. Shares are property which is transferable. So that means if shares are property, they are property of the company, not so? So if they are shares of the company has the power to deal with its property the way it deems fit. Okay? But the company deals with property that belongs to it, what we call the name of that rule. So then first ask yourself, what are the different ways through which a company can own shares? Okay? Because today they may give you facts when the company allotted all its shares and the shares were all paid up. Now, kati ngegenda kola etya nga terina na share yonna gyeyinza kutunda kola ki kujjamu sente. Okay? If not, bajja kuwa nga company shares zonna yazalootinga naye nga bonna tebasasula. That is also possible. If not, they'll give you facts where the company remained with some unallotted shares. So we have basically also three ways of how a company can own shares. One, by owning unallotted shares. If our company has 100 shares, okay, and these 100 shares, we allotted 40 and we have 60, that means we have unallotted shares. Okay, we have shares that are not allotted. That's the first way. Then the second way, where the shares were all allotted and paid up and the company has no shares, what remedy would you have, Senior Counsel? Counsel Faith? What remedy will you have? Okay.
Where your council, you've not given me the circumstance.
Where the company allotted all its shares. Okay. The company allotted all its shares. Okay.
But it needs to.
Yes. And now now it needs money. Okay.
They make calls on the unpaid up shares.
They are all paid up.
They are all paid up. Bakolayo shares endala.
Shares bazikola batya mukama wange? Ogenda mu dduuka.
What are they called? Premium something?
Those are types of shares. So the right remedy will be one. It is only one. Increase of share capital. Capital waffe bw'aba yali ku mitwalo 5 tugenda ku increase nga tumuteeke kakadde. Already gino emitwalo 5 already zo shares abantu bazikola ki? Bazirina. Kati bwe tu increase nga ku kakadde tugenda kufuna emitwalo emirala emeka? 5 ekitalina agamba. So bwe tu increase nga share capital ku mitwalo 10 kakadde tufunye emitwalo emirala 5. Then we turn that amount into new shares. Okay. Which take it?
Yes, sir.
Okay. That is the second way. Then the third way, okay, the third way is by forfeiting unpaid up shares. Okay. By forfeiting unpaid up shares. Okay. Why? Bwe tukubanja naawe kiteeke mu mbeera yaffe eya bulijjo. Bwe nkubanja ssente, okay, oba wanteresa olugoye lwo, okay, ne zikulema okuleeta, kugamba why? Komyawo ebintu byange. So that means ogenda zizza nkyeddize. So if we gave you shares and you have failed to pay up these shares, we shall take them back and they belong to the company. Okay. So what does that mean? Now the company has acquired shares now. Okay. Then ask yourself, after acquiring shares using the different ways, how can the company allot those shares? Then that takes us to what we call modes. That's when you'll see allotment of shares at a premium, allotment of shares at a discount, allotment of redeemable preferential shares, and ordinary shares. But otegedde how we get shares.
Kikyotegeeza how we get shares. Nsobye otegeera wonnyonnyodde gundi forfeiting and unpaid up shares.
Bwe tuforfeitinga company eba efunye shares, not so? We are either going to forfeit. If not, we shall increase the share capital. If not, we have shares that were not allotted. Tuyinawo shares ziri awo mu kisero. Okay? So we want to get money, but using these shares. The mode of getting money is known as allotment of shares. But this allotment, we have different ways on how we can allot these shares. Okay? So you sit and think, amongst the different ways of allotment of shares, okay, how best can I allot? Okay? Then you start. 1, you can allot what we call redeemable preference shares. 2, you can allot shares at a premium. 3, you can allot shares at a discount. 4, you can allot ordinary shares. Kati ezo zonna, you look at them and see 81%, it's the one you go with. Council kitegedde?
Kitegedde.
So let us go to the law that provides for allotment of shares now. Hope we are on the same page, you and I, my people. I know this thing is so confusing. That thing of allotment of shares. Yes?
Babuuza boogere.
Members, are we at the same page?
Mukyala Taikuni.
Okay, members, the rest, are we on the same page? Yes? Bavudde mu class.
We are on the same page.
Okay, so let's go to allotment of shares. Okay. Council Faith, you have the act. You have our act here.
I have my act. So ngenda ku section 61.
Yes, let's go to section 61.
Our act. Return on allotment. As to allotment.
Lindako council.
Once.
Wait. Let me confirm the exact sections. Wait, hold on a little bit. Hold on, guys. Ndabana. Oh, I'm looking for the exact section.
So no section kwa allotment. Naye ndowooza weegyeeri etali 61 because it's titled allotment.
Okay, let me first confirm. Hold on a bit. Okay, it's around 63. Not seeing the exact provision, but okay. Comes to section 63.
Subsection.
Yes, the very first one.
I'm reading holding and subsidiary companies.
66.
Issue of shares at premium, discount, and redeemable preference shares. Right?
Sikozeko. So the first one,
Application of premiums received on issue of shares.
So that is the first, okay, what we call issuance of shares at a premium. So issuance of shares at a premium kitegeeza nti share bweba original eri ku 5,000, okay, ogenda kugiteeka ku gumu kitundu, omuntu akkirize okugigula ku mmeka ugumu ekitundu. So a premium basically is the difference between the nominal capital, the nominal value of the share nezo zoba otunze. Era zigenda ku account gye tuyita the premium account mu lulimi olutuufu account ey'amagoba. So premium basically bagayita magoba g'okoze mu kutunda shares. Okay.
Lwaki tebagamba profit shares?
Why?
Let me read the section. Where a company issues shares at a premium, whether for cash or otherwise, a sum equal to the aggregate amount of value of the premiums on those shares shall be transferred to an account to be called the share premium account, and the provisions of this act relating to the reduction of the share capital of a company shall, except as provided in this section, apply as if the share premium account were paid up share capital of the company.
Okay, you see? So it applies only where such things are going to be. Okay? What's changed? Okay? So then another mode, we said it, power issuing of, so premium wojirava yekola sente. Okay? Council, proceed and read it too.
The share premium account may, notwithstanding anything in subsection 1, be applied by the company in the paying up and issued shares of the company to be issued to members of the company as fully paid bonus shares in writing of the preliminary expenses of the company, expenses of all the commission paid or discount allowed on any issue of shares or debentures of the company, or in providing for premium payable on redemption of any redeemable preference shares or of any debentures of the company.
Okay? So you see? So bojira ekulaga what the premium money does, agama goba gofuna. Okay? You pay all the expenses. Okay? You pay the commission. Okay? Ekulaga nti muno muvaamu sente ate zina ekyokukola already. Okay? Then the second way how you can allot those shares is by issuing shares at a discount. That's what take us to section 67.
Power to issue shares at a discount. Subject to this section, a company may issue at a discount shares in the company of a class already issued, except that the issue of shares at discount must be authorized by resolution passed in general meeting of the company and must be sanctioned by court.
Why? Tebamala sebo gasala muwendo gwa shares. Tuba tugenda kukola loss. Okay? Tunoonya sente ate gwogamba we issue shares at a discount oliko ekikyamu. So mwenna mumala kukkaanya.
Around this business of court sanctioning it.
Okay? So after passing the resolution, bweba yakikwangala, that's why we take it to court. Court etekeko siiru yaayo. Okay? Si byakumala gayigenda bwe batyo. Okay? Reason, tunoonya sente. So that means everything we are dealing with should be dealing with money. Okay? Then section 68, the third way is issuance of redeemable preference shares.
Hey, boss. Power to issue redeemable preference shares. Subject to this section, a company limited by shares may, if authorized by its articles, issue preference shares which are, or at the option of the company, are to be liable to be redeemed.
From the onset, the meaning of the word redeemable, okay?
Something you can get back.
Okay. Redeemable, something you give someone was already decided. Okay.
Should I proceed?
Mm-hmm.
So sometimes I do some personal talking. And then you get a concept. Subsection 2.
Mm-hmm.
Subsection 1 is subject to the following. Shares shall not be redeemed except out of profits of the company, which would otherwise be available for dividend or out of profits of
So now, listen. Those are what we call conditions of redeeming. That before you say, when we olako sent mu company, no redeemable shares, banga kwa the security. So the law is, before you proceed to do redemption, the following conditions should have been fulfilled. 1, the money I borrowed you should have made profits. Okay? Kati bwe zibanga tezikola magoba.
It's part of our task. No. I think that's it.
Okay? Another condition, proceed.
Shares shall not be redeemed unless they are fully paid.
So what does that mean? If I took those redeemable shares banja, mwina soka making a call on shares. Nemba sasura. Okay? Mwimalo basasura, then you proceed and redeem. Hey.
But I think the whole rationale for such shares would be that they are paid up, like in cash. Because we are doing it because we need money. You can't take them unpaid for. Well, that's my thinking. C. The premium, if any, payable on redemption must have been provided for out of profits of the company or out of company's share premium account before the shares are redeemed.
Kazungu. Yes.
Did not explain that the premium, if any, payable on redemption must have been provided for out of the profits of the company. So the amount to be paid must be from the profits of the company or on from the company's share premium account.
Yes. Nga company efunye ku sente neryoka emugamba sebo tuddize kwata sente zo tuzifunye. Okay.
B. Where shares are redeemed under this section otherwise than out of the proceeds of fresh issue, there shall, out of profits which would otherwise have been available for dividend, be transferred to a reverse fund to be called the Capital Redemption Reserve Fund, ARURA. Answer this one or
it says where shares are redeemed under this section otherwise than out of the proceeds of a fresh issue, there shall, out of profits which would otherwise have been available for the dividend, be transferred to a reserve fund to be called the Capital Redemption Reserve Fund. What this means, nti bwe tuba tetukozesezza premium account, tulina okuba nga tulina kyetuyita reserve fund. Okay? Nti sente zino ze baatuwola zennyini buli magoba ge tubadde tukola nga tugatadde ku kyetuyita reserve fund. Bwe tulaba nga ziwezeeyo kwe tuzijja ne tusasula ne batuddiza shares zaffe.
Ate fresh issue.
Anti kye kino fresh issue ng'ofunye ssente n'otundirawo, ng'ofunye ku shares n'otundirawo. Okay? nga si eri
bitegedde.
awo wewali obuzibu bwa problem awo. I have the sample, but it's not with me here. It's at office. Mulimu the summary of this thing. So when I get to office, I will send it to you probably. Okay. So that no. Okay. But you Megari temu musoma ako mumutyo musoma. So now, after that, the last mode, remember I said there are three. After issuance of shares, the last mode is known as the shareholders' loans. Okay? The shareholders' loans. Where the shareholder yekenyini omu company akuola. Okay. Okay.
Yes. Shareholder loans. That's the third one.
Okay. The under equity. Okay. So shareholders wekenyini bakuola.
Maola company.
Nga gwe bwowola maamawo oba kisista kyo ne kizirya. Okay.
Is there a specific section for that?
Yes.
Is there a specific section for shareholder loans?
No. Okay, it's just contract.
So execute a contract like a normal contract under section 10 of the Contracts Act.
Yes.
All right.
Okay.
Okay. So can I external?
External eryemu yokka. It is under Article 79. Yes, Article 79.
Borrowing money from a bank. Are they trade financing? Manya trade credit.
Sometimes, is it provided for under the Companies Act? So,
but the Act talks about. Still, the Act doesn't talk about it. But then it should be talking about that the securities that are created in the process of trade credit.
Yeah. Somehow, but basically, emphasis should be
Okay. May I cancel? Cancel.
So colleagues, so network had sent me out of class. So to see, appreciate how the company gets money. When a company it gets broke, it's like you in your funny hostel. Okay, if you have failed to get the money, so where do you expect others to get it? Okay, so you either accept nti bikusaze, okay, and proceed and do something else. Okay, so colleagues, any question? Any question, members? Yes. Members, any question? Want us to call off this session tomorrow morning as well? We are able to look at workshop 2. Okay. So if there is not any question, kindly allow me bring this session to an end.
So I've just joined. I was unaware about the session. I don't know if there's a recording such that I can also catch up. Unfortunately,
the
I've joined
the recording is coming. Yeah.
Okay.
Yeah, we've been recording.
Okay. Thank you so much. I'll settle.
Okay, you're welcome. Yeah. Okay, so guys, let me bring this session to an end. We shall meet tomorrow morning, inshallah.